Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
So a very big welcome back to part two of this podcast.
So you talked a little bit about kind of observing body language on remote hearing platforms. And I have done several arbitrations now as an arbitrator, remote hearings as an arbitrator, not as a practitioner yet, but I will hopefully soon. But in my view, it's funny. I actually feel like I see body language more on these remote platforms than I do in person. And it's also easier to focus on people and focus on their face and focus on their body language because of the kind of just, I guess, the proximity of the screen and the closeness. So I have actually feel like I can perceive body language and little just changes in emotion and visual reactions more so on the virtual platforms than in person. So I just wanted to get your take on that.
That's certainly interesting. I feel, look, I think we're coming at this from opposite ends, right? You're the arbitrator watching the witness. I'm the in-house counsel trying to read the arbitrators. And I don't know. I find it more difficult in Zoom and in a remote platform, and especially, I don't know, there's that element of like, you never know what's going on. Is somebody looking over here because, their dog's running down the hallway, or are they looking over there because they're getting coached? And I don't know. I see your point that you do get a much closer to the tribunal or to the witness than you would in a normal hearing setting. But I don't know, maybe I'm old school, but I tend to have a preference for everyone getting in the room. And I also think there's like some of that energy that's lost, right? Like it's, the adrenaline, the excitement, the formality of we are here at a hearing, everyone's wearing their business attire and not just from the top up, So that kind of gets lost. And I certainly worry about that for witnesses, especially that, they're not that they're not taking it seriously, but that they're missing some of that extra adrenaline that makes them pay a little more attention, that makes them think a little bit more about what they're about to say, just because they're sitting in their living room instead of in a hearing room.
Mm-hmm. Any thoughts on that, Adili?
Yeah, I did find it funny that folks are actually, I guess, dialing in or videoing in with just formal tops and party on the bottom. Is that what's going on, Shannon?
Yeah.
No comment.
No, I haven't participated in a remote hearing, so I don't have much personal experience with that.
Okay.
So Adili, we've heard Shannon's take on remote hearings. But when you're negotiating, how do you feel that works on a remote standpoint? Are there improvements? Are there risks? Are there challenges? How do you handle that?
Sure. Remote negotiations, I actually prefer them not to be by video. Well, I guess it's case by case, but one comes to mind that I'm engaged in currently, and it's more contentious than anything else. And I prefer not to have the video function on because the contentious nature of the back and forth, maybe seeing the other side humanizes them too much, I guess. but overall, I think it depends on the actual matter. So in the one I'm thinking about, where it's quite contentious, and we know at this point that we're not in a posture to kind of settle this disagreement. and our strategy is to kind of elongate the process. I think it's to our advantage that we're not on video, and to Chucky's earlier point, those cues that may be more perceptible because you're focused on, I guess, the shoulder up. You might see, you might glean our strategy in terms of maybe elongating the negotiation. So I think sometimes just having old school call where folks are just focused on words and the tone of voice and not you can kind of hide, I guess, better hide your emotions in terms of your physical appearance. So it just depends, but
so are you a negotiator who uses a lot of body language?
Well, I think body language in a negotiation, if it's kind of dispute related, I think it's important. You know, whether someone's bluffing or biding time, they're not focused. They could be multitasking, as sometimes we do, right? Or looking at their phones, or all that. So, and especially if there's a large number of participants. So if you look at all the screens, and there's a high percentage of folks who are not engaged, then that might clue you in that this is not of immediate concern, maybe for the other party.
Okay, well, thank you for that, Adili. So moving on, digressing, we are going to talk about Section 1782. And I'm not going to go into a bunch of background about it, because we've talked about it on several of our episodes. So if anybody needs to learn more about Section 1782, they can go back and listen to the episodes. But I do want to talk to Shannon about this, because I know she had some dealings with Section 1782, and as an outside lawyer, and I know that this is very interesting to her. So why don't I turn to you and just have you just give a little bit about Section 1782 and your work on it as an outside lawyer.
Yeah, so in my prior life, I worked on the Sixth Circuit case, the ALJ versus FedEx case, where the Sixth Circuit held that 1782 was available for private commercial arbitration, which has created some of the circuit split that is now now pending at the Supreme Court. We'll see. With 1782, it's always a challenge, right? Whether or not the Supreme Court will still have a live issue to decide, or if it's going to get mooted out before they can actually issue a decision. But it was very interesting to see that they're finally taking up the issue of whether 1782 applies for private commercial arbitrations or not. And so it's a case we're definitely watching very closely. So we haven't had too many instances where 1782 has come up in the context of an arbitration, but it's definitely an interesting theoretical question. You can see both sides of the argument, right? There's definitely arguments both sides can make, and we're definitely watching closely to see what the Supreme Court's going to do. Should they be able to actually rule on the decision and not have the case mooted out, which is, again, always our concern with 1782 and the Supreme Court.
So when you say mooted out, are you hearing things? Are you hearing about legislation or something that might pass before that would kind of make the issue clear?
No, I think. Well, I'm just more concerned, right? Like any of these the parties are going to settle, they're going to work out a discovery, whatever, and the case is just going to go away. The trial will happen or the arbitration will happen. I mean, you see that all the time, and that's
right. Thank you for that, Shannon. So Francisco?
Down in Mexico, I've been working as a Mexican attorney for the last, I would say, 10 years, following the energy reform, in maybe not the energy reform only. It's all the structural reform in the last decade in Mexico. And when I said the last decade in Mexico, is because I see two big things: the structural reform and kind of going in favor of the private investment in Mexico. And then in the last 2 years, within the same period of time, we have now Lopez Obrador that is coming with an opposite thing towards the market. Before this structural reform, I was looking as a Mexican attorney, kind of all different kind of disputes going to courts directly. And one of the things I was wondering to ask you, Shannon, specifically, was your opinion on how do you see that the disputes are moving now towards arbitration, and not only local arbitration, international arbitration. I do know that, for example, the big contracts, the big oil and gas contracts, where you guys are involved, always look for international arbitration. But in the case of Mexico, for specific situations, was dictated that it would have to be through tax courts. But maybe the question is, for all those contracts that are the service agreements that are related, what's the trend? What do you see that's happening down there in Mexico?
Yeah, and certainly as a non-Mexican lawyer, I would maybe even throw the question back to you, Francisco. But certainly what I've been seeing lately, right? Like in general, it is sort of, it's obviously still our preference, as investor side work that, we prefer arbitration over local courts in pretty much most jurisdictions throughout the world. And it's definitely, there's a lot of rumblings, and you see it in things like, UNCITRAL Working Group 3 that's trying to reform the international arbitration process and make it more court-like. And there seems to be a general, feeling throughout the world, and I would include Mexico with that a bit as well, in terms of trying to limit international arbitration, especially, and get more in the home courts. But I would throw it back to you as the Mexican attorney. What are you seeing, Francisco?
What I'm seeing is that, yes, there's a move on this one, but I do see that the clients are somehow looking to go to arbitration, depending the amount that's going to be involved. Looking for local arbitration, it's going to be language. And for example, for a global company like you guys would be looking the English version, the Spanish version. It's a little bit more beyond. And I would say is international arbitration the very good thing today to resolve disputes because of political and economic impacts?
Yeah, now that I agree with. I definitely think, we're very selective of when we actually go to arbitration, right? Like, our first choice is usually to come to an amicable resolution without actually needing to pull that arrow out of the quiver and go all the way to an arbitration. So, and definitely there are many disputes throughout the world that have, my group has been involved with at various points that we were able to cut off before we actually had to file an arbitration. We were actually able to reach some sort of agreement, and it sounds like Mexico is definitely one of those areas where hopefully stuff can get sorted out as well.
Yeah, and we see the trend in Mexico. We see this in other countries in Latin America as well. Yeah. It goes in up and down.
Exactly. Yeah, and obviously it's different when you're facing, for example, a direct expropriation, and there's no room to compromise on that. If you've taken my asset, at that point it's pretty clear where we're going. We're going to arbitration. But certainly for other disputes, that don't rise to that level of full taking of my property or my investment, it's definitely preferable to avoid the arbitration in the first place.
Good. Thank you.
Thank you. So can I suggest a bit of a geographical jump at this stage and shift us from Mexico to Africa? Adili, since you're based in West Africa, I wanted the chance to talk to you briefly about the African Continental Free Trade Area. Now, that's something not directly on the point of international arbitration, but it's something that I'm very excited about. So I've wanted a chance to squeeze into this episode. And we've seen it come into force this year. I think it's a very exciting development for the continent. We've got 36 countries which have ratified it so far. And it's the creation of the largest trade area, the largest free trade agreement, in fact, since the establishment of the WTO. Now, under the free trade agreement, a dispute resolution is governed by a set of procedures which essentially provide for state-to-state arbitration. So for those of you who listened to Chucky and I's earlier podcast on Brexit and the EU, we'll see parallels there between provisions there for state-to-state disputes and the provisions that the African Continental Free Trade Agreement puts in place. So I imagine for investors, largely investment protection will still remain under the provisions of either international arbitration or bilateral investment treaties if in place for the relevant country. But I was just interested to hear, Adili, whether you see any other issues or matters in relation to the continental free trade area, whether from your viewpoint and perspective in Equatorial Guinea, you see opportunities, risks, or other developments in relation to it.
Sure. I definitely share your excitement on the trade agreements. I think it's aspirational and hopefully obtains some of its goals. As you may know, the World Bank came out with some estimates. Obviously, these are aspirational in terms of implementation of the trade agreement and the regulations that will come forth, but they're estimating boost in economic growth, reduction in poverty that's material change. So just to remind folks, this is 1 billion people, as you said, a large market and $3 trillion market. So lots to be excited about, but also a lot of aspirational sentiment within the trade agreement so far. So in terms of challenges or disputes that I see arising from the trade agreement, I guess from my vantage point, being in Equatorial Guinea, my experience here in a monetary union, the CMAC, that's a collection of 6 Central and West African countries that share a currency, the franc, the CFA franc. I guess from my vantage point, there are issues that may arise in terms of implementation or legislation that arises from a supranational organization, right? So as a business here, oil and gas business here, you may have production sharing contracts or agreements with the sovereign, and then the sovereign may, in the future, strike or enact legislation that was required under a supranational treaty or union. So when that happens, there might be issues in terms of stabilization between your PSA or PSC and the new legislation. So those types of issues I can foresee happening with the trade agreement. If the trade agreement is implemented and regulations arise and are adopted in certain sovereigns, and those conflicts may arise with international agreements between businesses and the sovereign. So those types of issues I can see occurring, but that doesn't really hamper my excitement and hopefully the trade agreement is ratified by the entire African Union member states. And like you said, it's a huge deal, and looking forward to seeing what happens. As some of you know, there's several other regional unions, one in West Africa, there's one Eastern African community, and their target, I think it's 2024, to adopt a common currency. So you see a lot more of these trade agreements and organizational structures happening throughout the continent. So it's something I think we'll see more of.
Thanks a lot, Adili. So I guess it's that potential risk around inconsistency with existing arrangements, ensuring that they work together, and I suppose potentially a bit more work for you and for Shannon, and potentially also for the outsiders as well, possibly. But I think the bigger point is it's a massive trade area, and potentially transformative, and you and I and all of us on this podcast are excited to see if it reaches its true potential.
Definitely. Just to give you an example, I kind of looked up and saw that intra-continental trade in Africa is less than 15% of total trade on the continent. So that pales in comparison, of course, with the European zone, where you see member states having 30 to 80% trade within the union. Obviously, Europe is far more developed, but it kind of gives you insight into the opportunities on the continent. Another example in terms of trade, here, just my personal experience here in the CMAC zone, the kind of the goal of common market is the free movement of goods and people, right? And so as an American citizen here in EG, I actually was legally allowed to enter EG without a visa. But member states within the CMAC have to get a visa in order to come into EG. So someone from Cameroon wants to come to EG still has to get a visa. So although it's aspirational and a target for the free movement of people, it's still a challenge and developing. So
now there's a way to go, and then that's an important point. But it's hard to imagine it at the moment when no one's allowed to travel anyway. But it's yeah, we're a long ways away. But yeah, it's like I said, still aspirational, and you see some vestiges of colonialism in terms of the restrictions and tariffs that are on countries. It's sometimes easier to import something from the UK into Africa in certain countries because of the tariffs versus your next door or your neighbor. So that hopefully this trade agreement lessens those tariffs and produces and unleashes the economic vitality within the continent. Indeed.
What do you see in the next 2 years are going to be the kind of the disputes that are going to be in Latin America? And sorry, I didn't mention the issue of taking the plane back from Africa to America. Again, talking Latin America, what do you think is going to happen in the next 2 or 3 years with regard to the disputes here? Cases, matters?
Sure. I mean, neither Shannon and I are Latin American experts. So I think I'll talk kind of broadly in terms of what I see as some of those issues that are coming up within the next 2 years or so. Obviously, have to mention climate change, but I think climate change can be dealt with more in-depthly in a different podcast. But would like to focus on a kind of a lesser discussed issue that is tangentially, I guess, related, and that's kind of abandonment issues and decommissioning. That I think sometimes it gets left out of the discussion when we were talking about energy transition now, and I think that topic and that matter doesn't get talked about enough. Obviously, in Latin America, you do have some countries that have developed oil and gas histories, like Venezuela, and then you have new markets like Guyana and the work that's going on in Brazil currently. So you do have that dichotomy, but in kind of older or more mature states that have assets that have reached kind of their late life cycle, then you have those issues in terms of abandonment and decommissioning. And with the energy transition, you could have folks who are now facing that issue. So not sure if that's going to happen within the next 2 years, but I can definitely foresee those issues popping up and needing to be resolved, because as you know, Francisco, some of these agreements in terms of their abandonment obligation aren't very clear. Sometimes they're just agreements to agree later, right? We agree we're going to abandon, and we're going to abandon safely and ecologically, but the details are really left out. They're to be agreed to at a later date.
Can you, Adili, can you give people, just the listeners, kind of an idea of what type of costs you're talking about? What type of remediation costs you're talking about?
Sure. It depends on the nature of the assets, but my specific experience is deep water assets. So those are $1 billion projects. So in terms of decommissioning costs, you're looking at $500 million to $2 billion worth of cost in terms of decommissioning.
Mm-hmm. So you're talking about serious exposure for these disputes. Mm-hmm.
Sure. Yeah, these are hundreds of millions, if not billions of dollars in terms of costs.
Another thing that I think we're seeing a lot of, and I heard a stat this morning that I think it was 3/4 of all treaty claims that have been brought in the past 2 years are tax related. And that's certainly consistent with, our experience in a variety of countries, including countries in Latin America. And I wouldn't be surprised if we continue to see, states in an effort to, as they also face this global economy that's not doing so well, in an effort to try and extract a little bit more from international investors, if we continue to see a rise in disputes over tax issues. That's certainly something that we've been seeing a lot of.
Very good. Thank you, Adil. Thank you, Shannon. It was good to hear about it.
So I think that we might have covered everything that we wanted to cover today. Kwadwo, am I right, or did you have other questions?
Nothing else from me.
Okay. Well, look, thank you guys for coming and talking to us. And look, this is a wonderful discussion, and I'm sure our listeners will love it. So again, thank you, and hope to talk to you soon.
Thank you
so much for having us.
Thank you, Kwadwo.
Yeah,
a long-time podcast listener and first-time guest, so get to check this off the bucket list.
Right. Yeah, look, and also for our, speaking of that, and I'm purposely not going to kind of direct people to YouTube, but I do want to ask Adili about a picture, and I'm describing it as I guess it's a very colorful picture, and looks authentic. And can you tell us a little bit about the picture behind you?
Yeah, sure. It's a painting by a local artist here, a Ghanaian artist here, commissioned by us, by Maggie, and it's represents our history here in Equatorial Guinea over 25 years operating here, and kind of the local flavor of Malabo. It has the famous ceiba tree that's a unique tree native to here in Equatorial Guinea, and then has in the background, if I move my head, you can see Mount Pico, mountain here on the island of Bioko. So it's a picturesque island where you have the sea to one side of us and the mountain to kind of to the back, depending on where you're situated. But it's colorful, yeah, and I like it.
It sounds well. Look, sounds. I like it. I like it as well. It's great. So maybe that's a great way to end our podcast today. So thank you guys.
Thank you so much
all
for having us.
Thank you so much.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcasts. Thank you for listening.